The double taxation agreement between Kenya and Mauritius was nullified by Kenya's High Court on the 15th of March. In his judgment, Judge Edward Muriithi pointed out that the DTA was not laid before Parliament for ratification. Not complying with the Kenyan Statutory Instruments Act, he said, the agreement is therefore null and void. Now, the case challenging the DTA had been launched by the East African unit of the Tax Justice Network, which argued in part that the deal would cause tax revenue losses for the Kenyan state. Now, let's flip back a bit here. When the agreement was originally gazetted, this was back in 2014, PricewaterhouseCoopers Kenya outlet argued that the reduced withholding tax rates on dividends, among other issues, makes it advantageous to hold Kenyan investments using a Mauritius holding company. And that was one of several other benefits that it did outline in a note to clients. Mauritius, of course, does have an outsized presence as a hub for capital flows into Africa and other parts of the world as well. It's a preferred business destination for quite a few enterprises. It's not only ranked first in the ease of doing business reports on the World Bank, it also has a relatively lower income tax rate on both personal and corporate income compared to other economies on the continent. Top tax rates of 15% on both of those categories. So then, what does this mean for companies that have subsidiaries in both countries, as well as Kenya's tax revenue base as well? Let's find out. Jared Maranga is the policy lead on tax and investments at that advocacy groups, TJN. He's live in studio with me tonight. Thank you for coming.
Thank you, Ron.
So in a nutshell, for those of us who are not tax experts, explain to us why this deal was not productive for the Kenyan government.
So basically, regarding the double tax agreement between Kenya and Mauritius, what was looked at basically was the fact that Tax Justice Network Africa carried out a series of research prior to the signing of the DTA, which led to inform that there are so many flaws that are contained in the DTAs that have been signed, majorly in sub-Saharan Africa. And since then, after that, then there was a signing of the DTAs between Mauritius and Kenya, so which followed after the researches that have been done. So this informed from the findings that there is a need for us to relook at the kind of processes that were put in place in terms of putting the DTAs into signing the DTAs into action or into force.
But looking at your petition to the court, one of the main arguments that you made at the time was, when you being TJN, one of the arguments you made was that this was counterproductive for the Kenyan tax base because it would reduce the amount of income that the Kenyan government could legally collect from government. But then I look at the judgment, and the judgment was decided purely on a legal technicality matter, a matter of process. This step did not happen. It was not laid before Parliament. Therefore, it's null and void. Why did the court not touch the economic side of the case?
Okay, the court did not look at the technical part of it, basically because part of our asks were purely on constitutional arrangement and the rule of law, how the process has been done. But again, to substantiate the kind of argument that we put in place, we had to look at the technical aspects that contained in that DTA. And among them, we realized that there are reduced tax rates. When you look at them and compare comparatively with the tax rates that Kenya has, then you realize there could be some level of compromise that will come in, which will create avenues for tax planning, especially through the issues of tax treaty shopping and also round-tripping aspects, which essentially will affect the tax base of Kenya, considering if we're going to have probably the head offices or the holding companies moving out of Kenya to Mauritius, what that means is that maybe if they're going to pay out dividends from Kenya, then it means those dividends will not be productive in the country, and essentially that means that we have capped the tax base that is going to be subjected for productivity in our country.
Are there instances you can cite where a company, a multinational or a large Kenyan firm has been taken to court and charged with essentially tax planning purposes, or rather with tax planning? Because even if you look at the NSE listed firms, for instance, there are quite a few that do have outlets or subsidiaries that are based in Mauritius, and it's a favorite haven for private equity firms as well.
At the moment, it's very hard to come out clearly with a specific example of a company that has been really charged of tax planning. But again, looking at the way the DTA has been structured, it provides that avenue of tax planning. And that's why we had to go and try to see what mechanisms can the government put in place to cap such kind of issues arising in the near future.
Right. So one of the things that struck me about the way the judgment had been set up, the judge said that basically, yes, we've struck this down, but you cannot, therefore, it doesn't affect arrangements that were in place for the duration of the DTA. But now that this DTA has essentially been nullified, and of course there might be an appeal from the government, we're not sure if that's coming up just yet, but it's reasonable to expect one. How does this then change the tax base for multinationals based here? What extra costs are they facing?
So you will note that even with the nullification of the DTA, so the judgment that was delivered on 15th of March, basically the DTA has never been enforced since it was ratified by both governments. So which means it has never been really implemented. So therefore, at the moment, we cannot be able to say that we can measure adequately what is going to be relatively the difference, considering that the nullification and what was there before. So unless it could have been implemented, that is when we could have looked at what could be like the gains that will come as a result of that nullification. But at the moment, it's like we are in a status quo.
But related to that, is there, given the fact that this DTA never went into effect, the Mauritian side never ratified it, although the Kenyan side did, what's the advantage then for operating from Mauritius? Because it doesn't seem like there's a definitive tax advantage.
As you indicated clearly in your introductory remarks, is that the corporate tax rates in Mauritius comparatively to the corporate tax rates in Kenya, you know that there is a really huge difference. And initially, Mauritius has been operating like two-tier, let me say, call them legal firms, legal formations of corporations. We had what we call GPC1 and GPC2. You realize if you're operating a GPC2, initially it was exempt from taxation. And if you're operating a GPC1, then there is that advantage of having 15% corporation tax rate. Yeah. So if you compare that, you have that advantage. If you were to do a net effect, then effectively, if you are a Kenyan operation moving out to Mauritius, you're going to have like a 15% saving in terms of taxation or tax liabilities. So I think that can drive the kind of arrangement or planning that a multinational or a corporation can do so that it can minimize the tax costs.
All right, we'll leave it there for the time being. Jared Maranga from CGTN. Thank you very much.
Thank you.